good morning, good afternoon, whatever is the correct greeting of the day where you are. If this is your first time here, welcome. I hope you get some valuable information. Okay, so let me just share my screen and let's get this started. Okay, so who is the ICCP? Sorry, there we go. Okay, well, we are a professional members organization that exists to recognize the skills and qualifications needed to manage construction claims. So we have three main objectives. The first is to establish international standards. The second is to give recognition for those who have gained the appropriate knowledge and skills. And finally, to help and educate those who would like to gain experience in the management of claims. Okay, so why is there a need for the ICCP when there are so many other construction organizations? Well, construction claims continue to become more and more important in the international construction industry. And people come into claims from many different backgrounds. Some come from quantity surveying, engineering, some are lawyers. People come from many different backgrounds, and they deserve the recognition of the industry, which until the ICCP, there was no organization which existed solely to work with people who have the specialist knowledge, experience, and skills necessary to manage claims to the highest degree possible. Okay, so I am not going to introduce everyone. I will just quickly say that we have our founder and executive officer, Andy Hewitt. Our current elected president is Paul Gibbons. We have 3 elected fellows, and Nina Hewitt Tyrell is our general manager. She is currently on maternity leave, so I am currently filling in for her. Okay, so how could you become part of the ICCP? Well, we have 3 levels of regular individual membership with their own criteria. We also have a student and graduate membership for those who are studying for a construction qualification and want to work in claims. And students can then graduate and become graduate members as they work toward having enough claims experience to become an associate. We also have a corporate level of membership for consultancies and other companies that specialize in construction claims or have a department dedicated to claims management. Okay, so what's in it for you? What do members get out of their membership? Well, we have a private members area of our website, which has a knowledge bank of white papers, case studies, articles, etc., on contracts and claims issues. We have information about various education programs for those who want a further qualification. We have information about various trainings that you can find either online or offline. Our bookshop does not sell books, but we do review related releases. We have a growing library of templates to help our members make sure that their claims are to the highest standards while also saving time. We have regular CPD webinars like this one, so members who are attending today will receive a CPD certificate. That is a benefit of membership. We also have the ICCP Academy, which are more technical trainings, which are only open to members. We have discounts on books and trainings through Wiley Blackwell, Rutledge, and Claims Class. We have a monthly newsletter to keep our members up to date on what's happening at the ICCP and around the world in construction claims. We have industry exposure and logos for our members. So the industry exposure is in the form of a public listing on our website, and members get certificates and logos that they can use to show that they're members and their designation. We have a private LinkedIn group where members can discuss their contracts and claims questions in a confidential setting. And we have the optional benefit of the Register of Claims Practitioners, where members who would like to increase their online profile can get their own webpage. Okay, that was pretty quick, I know. So if you would like to learn more, please either visit our website, instituteccp.com, or email me, jennifer.smith@instituteccp.com, or you can also email membership@instituteccp.com. If you requested further information when you registered for this webinar, I will be getting in touch with you with more information. And with that whistle-stop tour of the ICCP, who we are and what we do, I will now turn it over to our presenter and one of our fellows, David Kaggwa.
Good morning, wherever you are. Today, I'm going to make a presentation about employers' claims for liquidated damages. I'll go briefly through the introduction, my introduction. I'm a construction arbitrator and a lawyer. I am the chairman of the Chartered Institute of Arbitrators Uganda chapter. I'm a senior partner at Kaggwa Advocates, a specialist law firm in Uganda that does arbitration and construction claims. I'm a fellow of the Chartered Institute of Arbitrators, a fellow of the Institute of Construction Claims Practitioners, a member of Society for Construction Law for Africa. I also hold a Master of Laws degree in Construction Law and Arbitration. So today's webinar, we're going to look at what are liquidated damages. They are sometimes called delay damages, depending on which standard book you're referring to. How do they arise? Elements of a claim for delay damages, enforcement of delay damages, penalty clauses. So I'll be reviewing some case law from all over the world. How have the judges and arbitrators looked at these topics? Then we shall also discuss the prevention principle and time at large. Now there's a quick poll. There's a question. Liquidated damages are meant to punish the contractor for breach of contract. Let's have, there it is. So I'll go straight to the introduction. What are liquidated damages? In the FIDIC 2017 Red Book, subclause 1.1.28, delay damages mean the damages for which the contractor shall be liable under subclause 8.8, delay damages, for failure to comply with subclause 8.2, time for completion. Now, the term liquidated damages is used in the JCT contract, while delay damages is used in the FIDIC contract. But they all relate to a pre-agreed fixed sum to which the contractor is liable to pay the employer should it fail to complete the works by the time for completion. Now, these funds, the liquidated damages or delay damages, are typically deducted from what the employer owes the contractor for the work executed. This usually happens at the point of the final account. Now, time for completion means the time for completing the works or a section under subclause 8.2, time for completion, as stated in the contract data, as may be extended under subclause 8.5, extension of time for completion, calculated from the commencement date. Please take note that under the FIDIC 2017, what we used to know as the appendix to tender is now called contract data, but it means one and the same. Commencement date means the date as stated in the engineer's notice issued under subclause 8.1, commencement of works. The FIDIC 1999 Red Book, subclause 8.7, provides that these delay damages shall be the sum stated in the appendix to tender, which now means contract data, which shall be paid for every day which shall elapse between the relevant time for completion and the date stated in the taking over certificate. You will see that there's a difference in wording with the 2017 Red Book. They use contract data instead of appendix to tender, but it means one and the same. But then they also, here in 1999, there is the date stated in the taking over certificate. It's a bit different. with the new books. The FIDIC 2017 subclause 8.8 states that delay damages is the amount stated in the contract data, which shall be paid for every day which shall elapse between the time for completion and the date for completion of the works or section. You realize in this clause, there is no option for the taking over certificate, but the date for completion of the works or section. The benefit of delay damages is that they avoid the complexity of proving and assessing the actual loss where a delay occurs. In essence, the parties pre-agree that in the event of delay, a certain percentage of the contract sum shall be charged on a daily basis and is usually capped. So there's no need for the employer to prepare spreadsheets detailing their loss once this has been pre-agreed.
I'll just let you know that, sorry to interrupt, I'll just let you know that I have stopped the poll. So anytime you want to show the results, just let me know and I'll share them. Okay?
Okay. To avoid payment of delay damages, in case of an employer-caused delay, a contractor must follow the claim procedure under the FIDIC 2017 subclause 20.2, claims for payment and/or extension of time, and obtain an extension of time. The purpose of an extension of time is to negate any claim for delay damages during the extended period. So what this means is, if there is an original agreed completion date, and for whatever reason the contractor is not able to finish on that date, the delay damages will come into bite. But if you get an extension of time, you will be excused from paying the delay damages for only the extended period. Now, I've just made a summary in this table to show the distinction, most especially on the clause for delay damages. Under subclause 8.7, FIDIC 1999, the employer is to issue a notice subject to subclause 2.5, employer's claims. Now, you realize that under the FIDIC 1999, employer's claims were specifically stated under subclause 2.5, and they were separate from the contractor's claims, which had a different clause, subclause 20.1. Now, subclause 8.8 of the FIDIC 2017, the employer is to give a notice subject to subclause 20.2, claims for payment and/or extension of time. Now, under the FIDIC 2017, the claims for an employer and those of the contractor are under the same subclause 20.2. There isn't a similar subclause 2.5 as it were in 1999. Now, notice has to be given as soon as practicable. That is the wording in the clause 8.7, the FIDIC 1999. In 2017, notice must be given within 28 days. Now, you realize that there is a condition precedent that applies to both employers' claims and contractors' claims in the FIDIC 2017. Yet previously, the condition precedent of 28 days only applied to contractors' claims. So previously, in 1999, an employer would give notice as soon as practicable. There was never a limit for the 28 days. Now, in 8.7 FIDIC 1999, the claim procedure was simpler. We shall show you, I'm going to discuss a certain case law where the court stated that the right to delay damages is contractual and that an employer doesn't need even to go through the claim procedure to be entitled to delay damages, since in any case, the parties had agreed from the onset. Now, under the FIDIC 2017, there is a detailed claim procedure that must be followed by both the employer and the contractor. Another distinction is that in 1999, delay damages are capped as stated in the appendix to tender. The wording in 2017 is contract data, but it means one and the same. They are still capped under 2017. However, that cap will not apply in case of fraud, deliberate default, or reckless misconduct by the contractor. You realize that this exception was not there in the 1999 FIDIC book. So what are the elements of a claim for delay damages? One, there must be a contract with a clause that allows a claim for delay damages. This is quite straightforward because they are pre-agreed. So both parties must have agreed to them, the contract. 2, the contract must have a date for practical completion or a mechanism to extend such a date. The rationale is that it is only after the date for practical completion has lapsed that if the contract has not finished, that then the delay damages start to bite. So without a date for practical completion, there is no method in which you can compute delay damages. Thirdly, the contract must include a mechanism for computation of delay damages. This is usually seen in the appendix to tender if you are looking at the 1999 contract, or the contract data if it is 2017. It's basically a percentage that is going to be charged on a daily basis for those days that the contractor remains without completing the works. Now, how to claim for delay damages? The FIDIC subclause 2.5, 1999, and subclauses 8.8 and 20.2, 2017, I'm referring to the Red Book. The employer's right to claim delay damages from the contractor is well stipulated. So you don't need to reinvent the wheel. FIDIC contracts have these clauses well written. The delay damages are expressed in the contract data as a percentage of the final contract sum. These damages can also be capped at a maximum percentage of the final contract price. In both the FIDIC 1999 and 2017, the employer is required to issue a notice as a prerequisite for its claim for delay damages. Now, the distinction here, as earlier stated, is that whereas in 1999, there was no time limit of 28 days, it was only as soon as practicable. In 2017, there's a time frame of 28 days, short of which the employer would lose their claim. Notice by the employer. Now, there's a decision from the Court of Trinidad and Tobago, NH International Caribbean versus National Insurance Property Development Company Limited. The court said it is hard to see how the words of clause 2.5, this is FIDIC 1999, would be clearer. Its purpose is to ensure that claims which an employer wishes to raise, whether or not they're intended to be relied on as setups or cross claims, should not be allowed unless they have been the subject of a notice, which must have been given as soon as practicable. What this decision means is that the requirement to give a notice by the employer must be complied with before the employer claims delay damages or before they deduct. There is a case which has a different way of putting it. We shall go to that. So, whereas an employer is obliged to issue a notice to the contractor and present a claim for delay damages before the engineer, who is obliged to issue a determination under the FIDIC subclause 3.5, that's the Red Book 1999. The court had a different view in J. Murphy and Sons versus Beckton Energy, that the employer's right to delay damages was not conditional upon an agreement or determination by the engineer. In essence, in this case, the employer called on to a performance bond based on their claim for delay damages, but before they would issue the notice. The contractor claimed that the claim was that the act of cashing the guarantee was fraudulent since the employer had not gone through the claim process. The court disagreed. The court said that subclause 8.7 set out a self-contained regime for the trigger and payment of delay damages. A call on the bond would not be found to be fraudulent where the employer believed it was entitled to delay damages under subclause 8.7, even though no entitlement had been determined under subclauses 2.5 and 3.5. What this case means is that even in the absence of a determination by the engineer under subclause 3.5, an employer can as well cash a guarantee to take benefit of their delay damages, since in any case, they were pre-agreed. The amount of delay damages must be a reasonable estimate of the anticipated or actual loss caused to the employer by the delay. The UK Supreme Court laid down the test in Cavendish Square Holding BV versus Talal El Makdesi. The test is whether the delay damages clause protects any legitimate business interest. If so, whether the clause is extravagant, exorbitant, or unconscionable. In cases where delay damages are proved to be unconscionable, such a clause may be declared by a court to be unenforceable. Unconscionable means grossly unfair. In Triple Point Technology Inc. versus PTT Public Company Limited, the Supreme Court in the UK clarified that liquidated damages are payable up to the date of termination, with general damages available thereafter. In essence, you just cannot continue computing liquidated damages even after the contract has been terminated. Well, there will be different arguments towards this decision, but that's what it is. The employer's interest is to have the contractor perform the contract. The employer cannot have an interest in simply punishing the contractor. What this means is the level of liquidated damages must be fair enough to compensate the employer for their loss and not so exorbitant as to punish the contractor. So in Uganda, where I practice and where I am right now, the High Court made a decision in Rocco Construction versus Kopsinja Janet. The judge set aside part of the arbitral award. And his reasoning was that liquidated damages are a way of pre-estimating the loss that will be suffered, usually as a result of delay at the time the contract is entered into. In this sense, liquidated damages provide certainty to both parties whose rights and liabilities are now fixed. A valid and mandatory liquidated damages clause, which stipulates a positive amount of liquidated damages, will evidence an intention by the parties that general damages cannot be claimed. The award of general damages, on top of or in addition to liquidated damages and ascertained damages, is a fundamentally erroneous proposition of the law stated in the award, such that the serious irregularity has occurred, which has caused substantial injustice to the applicant. What this means is, where there is a pre-agreed amount of liquidated damages, an arbitrator has no jurisdiction to grant general damages over and above liquidated damages or delayed damages that were agreed. The import of this case is that the main purpose of liquidated damages or delayed damages is that both parties are aware. One, the employer is aware about the amount they will get in case the contractor doesn't complete, and the contractor is also aware of their risk in case they do not complete on time. So the court said you cannot give any amount over and above what was pre-agreed. So delayed damages as a penalty. As you know, many contractors would wish to set aside a clause on delayed damages because it reduces on their profitability. So employers must be careful to ensure that the clause is not a penalty. So what is a penalty? A penalty is a contractual clause that imposes liquidated damages that are unreasonably high. Such damages represent a punishment for breach rather than a reasonable forecast of damages for the harm that is caused by the breach. A contractor may challenge a delay damages clause if he argues that it is a penalty and not a genuine estimate of the losses that will be incurred by the employer as a result of delays. In South Africa, under the Conventional Penalties Act, the court can reduce the amount of delay damages that might be applicable if the contractor can show that the employer will be unjustly enriched if he receives the delay damages as specified in the contract. In the UAE, the court is empowered to vary the parties' agreement on delay damages to reflect the actual loss by reducing the employer's claim or by setting them aside entirely. If the amount to be paid as delay damages is greater than that which ought to have been paid, then it's a penalty. This is the English decision of Dunlop Pneumatic Tire Company Limited versus New Garage and Motor Limited. In Global Constructions, Pty versus Juniper Developer, the Supreme Court in Queensland held that in determining whether a rate of liquidated damages stipulated in the contract constitutes a genuine pre-estimate of the non-defaulting party's loss, consideration must be given to the parties' negotiations in respect of liquidated damages. The employer had provided to the contractor a detailed breakdown of its potential loss if practical completion of the project had not been achieved. The parties had equal bargaining power at the time of negotiating the contract. What this case means is, at the time of negotiating the contract, the employer has a duty to explain to the contractor that if it's a commercial building and it is not completed on time, they'll be able to lose rent on a monthly basis, and that rent needs to have a figure attached to it. So that should be the basis upon which liquidated damages should be computed, and then this must be included in the contract data or the appendix to tender. The losses that will be suffered by the non-defaulted party as a result of it being unable to use the works or the site from the date it could expect to, as per the time frame for completion, must be accurately reflected by the rate specified in the contract data. The Supreme Court held that the liquidated damages clause was a genuine pre-estimate of loss and therefore upheld the clause. The onus, of course, is on the contractor to show that the penalty is out of proportion to the loss suffered by the employer. The onus means burden of proof. Now we go to the prevention principle. The prevention principle is a legal doctrine that protects a contractor from liquidated damages for delays caused by the employer. The rationale for the rule is that a party to contract should not be permitted to profit from its own default. An employer may not enforce a delay damages clause against a contractor where it is proved by the contractor that it was prevented by the employer from performing its obligations under the contract. The prevention principle, in any case, is a basis upon which contractors seek to set aside liquidated damages clauses or delay damages clauses. Lord Denning in Amalgamated Building Contractors Limited versus Waltham Holy Cross Urban District Council said, the building owner cannot insist on a condition if it is his own fault that the condition has not been fulfilled. Brooking Jane SMK Cabinets versus Healy Modern Electrics Pty described the prevention principle as being grounded upon consideration of fairness and reasonableness. Contractor may rely on the prevention principle in cases of breach of contract by the employer, such as failure to give access to site under subclause 2.1, FIDIC 1999, or a delay in issuing designs or instructions under subclause 1. The prevention principle would also apply even when the employer's actions are legitimate, such as issuing a variation instruction under subclause 13.1. In essence, for the prevention principle to apply, there need not be a breach of contract, even a legitimate exercise by the employer, for as long as it prevents the contractor from completing the works within the agreed time, is sufficient to be used under the prevention principle. This principle was set out in Trollope and Coles Limited versus Northwest Metropolitan Regional Hospital Board, where the court held that it is well settled that in building contracts and in other contracts too, when there is a stipulation for work to be done in a limited time, if the other party by his conduct, it may be legitimate conduct, such as ordering extra work, renders it impossible or impracticable for the other party to do his work within the stipulated time, then the one whose conduct caused the trouble can no longer insist upon the strict adherence to the time stated. He cannot claim any penalties or liquidated damages for non-completion during that time. So if the employer does not extend the contract, or there are no mechanisms for extension of the contract, the contractor may rely on the prevention principle and avoid paying delay damages. There are some employers who, while dealing with the FIDIC contracts, delete the clause on extension of time. Now, the risk is that there will not be a mechanism for extension of time, and then such an employer will not be able to claim delay damages in the event that the works are delayed, since there is no mechanism for extension of time. Now, under FIDIC subclause 8.5e, it allows the contractor to claim for extension of time for any delay, impediment, or prevention caused by or attributable to the employer. Now, FIDIC included this clause to kind of cure the lacuna that existed. Previously, if you had any delay which was not specifically provided for in the contract, there was no mechanism to claim an extension of time. Now, this clause is broad. It allows for any delay or impediment or prevention. So anything that may arise that is not included in the contract, bring your claim under subclause 8.5e and apply for extension. The above clause was meant to provide a solution to the prevention principle in that a contractor must claim for extension of time when prevented. If not, this will safeguard the employer's right to delay damages. Claim at large, where the contract does not provide for how to deal with an employer's delay, or if the engineer ignores the contractor's request for extension of time, the employer will no longer be entitled to require the contractor to complete the works by the contractual time for completion. Therefore, time will be at large. In Miller versus London County Council, the court found that the failure by the architect, who was the project manager, to extend the time would be fatal to the claim for liquidated damages. I've highlighted this before, that where the engineer ignores the contractor's request for extension of time, amidst a clear prevention by the employer, time can be at large. In situations where the original completion date ceases to apply, time will be at large, and the contractor is required to complete the works within a reasonable time. When time is at large, the employer is not entitled to late damages, but to general damages in case the contractor fails to complete the works within a reasonable time. Now, reasonable time for completion is a matter of fact to be decided by a court or arbitrator when the claim arises, but the contractor bears the burden. You realize that this creates uncertainty, unlike if there was a clear delay damages clause and if time had been extended. In conclusion, the primary purpose of an extension of time provision is to preserve the contractor's obligation to complete within a specified time and to avoid time being at large. The extension of time, subclause 8.5 FIDIC 2017, preserves the employer's right to delay damages under the contract, even when, by an act of prevention, the employer has delayed the contractor and is responsible in part for the late completion. The contract data on delay damages must be reasonable in relation to the employer's loss in case of delay in completion. The rationale, obviously, is that this will prevent a contractor from going to the court to seek for these delay damages to be set aside. Jennifer, can we get the response from the poll? And then we can handle
yes, here we go. Can you see that?
I can see. Are liquidated damages meant to punish the contractor? Yes, 31%. No, 67%. Unsure, 3%. So from my presentation, you can clearly see that once a liquidated damages clause appears meant to punish the contractor, then it is unenforceable. So a court can set it aside. The rationale is that a liquidated damages provision is meant to ensure that the contractor performs their contract. So it must be reasonable. It is not meant to punish. But thank you all for participating in the poll. So I'll go to the Q&A. There's some questions. In case there are any questions.
The first question, can a penalty be also set in the contract data? I believe this should be made clear from the onset to prevent an unfair decision.
Yes, penalty. Now, the answer is, first of all, in my presentation, I said the penalty is not enforceable. In many jurisdictions, you'll find that once you put a clause that is intended to punish a contractor, there's a likelihood that such a clause will not be enforceable. So what is the purpose of putting a penalty in the contract data if you know that you'll not benefit from its enforceability? So the answer is no. It will be an exercise in futility to put a clause that cannot be enforced.
Okay, thank you. The next question are, how are the delay damages estimated?
Now, it depends on the type of contract. Sometimes if you're dealing with a FIDIC yellow book, which is involving, for example, the installation of some plant and equipment, the employer has a duty at the time of signing the contract to disclose the amount of money they expect from that equipment or from that plant. that they'll be making so every day or every month. And then once this communication is put before the contractor, they'll be saying that in the event of delay, this is the amount of money the employer will be losing on a daily basis. So that way you can estimate it based on how much money you'll be losing if completion is delayed. It's a bit different if it were a building, for example, under the Red Book, then you can look at how much rent you'll be losing on a daily basis. For as long as the delay damages are closely linked to the actual loss that the employer would suffer in case of a delay, any court or arbitrator will enforce
it. Thank you. The next question, sorry, I just realized my camera was off, says, sir, I came across a case where the employer granted, I think that's supposed to be 2 months of EOT without liquidated damages. However, for the other 3 months of the EOT, the employer, while granting the EOTs, stating liquidated damages will be applicable. Is the employer entitled to a liquidated damage claim?
The answer is no. The moment you grant extension of time, then liquidated damages are out of the way. You cannot have both at the same time. However, if the contractor does not finish within the period that is stated in the extension of time, then liquidated damages start biting.
Okay, thank you. The next question, what are general damages?
General damages, it's a remedy at law, which is usually granted by an arbitrator or a court, which as much as possible tries to put the innocent party into the same position they would have been in hadn't a breach occurred. For example, if a delay damages clause has been rendered unenforceable, a court or arbitrator can look at how much loss an employer lost from failure to collect rent or from running their plant and equipment and estimate their loss, say, on a daily or monthly basis, and grant that amount to the innocent party, usually the employer. So, but general damages can also apply to a contractor in case an award of interest is not commensurate to put them in the same position had there been no breach. But as you may know, arbitrators are very reluctant to grant general damages where the parties have pre-agreed an amount. For example, where delay damages have been pre-agreed, then usually arbitrators or courts are reluctant to grant general damages.
The next question, is there a chance to change the amount agreed as liquidated damages if found later that it was an unreasonable amount?
Absolutely. There is freedom of contract. The parties can change their terms of the bargain at any time, even after termination, because liquidated damages are payable even after termination. So the parties can agree that, look, if this is unreasonable, can we come up with a figure which is reasonable, such that you don't have challenges before an arbitrator or a court? So yes, you can change them at any time.
Okay. Where an engineer did not make a decision for an extension of time before the time stated for completion, can the contract time be at large?
Absolutely. I've already shared with you that English decision. There's a duty on the engineer to make a decision for extension of time whenever the application is put before them. So the risk that the employer suffers is that time can be at large.
Do you have any knowledge about delay damages in Morocco or other civil law countries in Africa? Will it be hidden in the procurement codes?
I'm sorry, I don't have any case law from Morocco, but the few cases I've read in civil law countries in Africa is the courts are very much inclined to set aside delay damages clauses as penalties or to reduce them. It is mainly common law jurisdictions that enforce delay damages as they are. Some civil law countries are much more inclined to make sure that the amount claimed is fair and reasonable. But I don't have any specific cases from Morocco. I'm sorry.
In case of default by a contractor, can we forfeit the performance security in addition to the imposition of the liquidated damages?
Yes. Sometimes the liquidated, the purpose of a performance security is to ensure that there is performance and that in case of breach of contract, an employer can enforce it. But it should be enforced to the extent that the employer is entitled to that amount. So it depends. If the performance security is less than the total amount of liquidated damages, then an employer is entitled to cash it and also claim for the difference in liquidated damages. If the liquidated damages are less than the amount in the performance security, then the employer is only entitled to the extent of liquidated damages. Because an employer cannot be entitled to any more money over and above the liquidated damages that are stated, unless, of course, there has been fraud or misrepresentation or undue influence or any fraudulent conduct by the contractor. So those are the exceptions.
The next question, in general, can the employer impose the delay damages without submitting a claim?
Yes, it's however risky. I've shared with you a decision which shows that the fact that delay damages are pre-agreed under the contract, then an employer is entitled to them with or without a claim. In essence, they're saying that the contractual remedy. One example I'll give you of a contractual remedy is a contractor's claim for interest. With or without a claim, they are entitled to interest if their payment is delayed. But it's risky. Some courts or some arbitrators may refuse an employer from deducting delay damages without a notice, but others would accept. So there's a gray area to that extent.
Okay, thank you. And I feel obligated as a representative of the ICCP to say, get your claims in on time.
Absolutely.
Okay, the next question. On one of the slides, the percent of liquidated damages is linked to the final contract price instead of, I believe, the accepted contract amount. If linked to the final contract price, it would be unset or a fluctual amount, perceived more as a penalty, not actual losses. Please comment.
I agree with you 100%. The liquidated damages or delay damages must be linked to the accepted contract amount because it is pre-agreed at the time of execution. So you cannot predict what will happen along the way. So that way it creates certainty for both parties. So it is the accepted contract amount, not the final contract price.
Is there any agreed percentage for delay damages, or can employees raise the damage percent?
There is not any agreed percentage because every contract is negotiated differently. Though it's very common that it is capped, delay damages sometimes should not exceed, say, 10% or 5% of the contract sum. But there is no any agreed percentage for delay damages. Depends on each contract.
In a supplement to my question, in the event the contractor abandons their work. So the previous question was, in case of default by a contractor, can we forfeit performance security in addition to the imposition of the liquidated damages? And then the added information, in the event the contractor abandons their work.
Yes, they can forfeit both, but like I've said, the contractor's liability to the employer is only limited to the delay damages or liquidated damages that are agreed in the contract. If the employer wants any more money over and above that, they need to prove extraneous circumstances such as fraud or undue influence or willful misconduct. But they can lose both for as long as the performance bond is less than the liquidated damages that are payable.
Okay, thank you. Right, next question. If the project is delayed due to COVID, can the employer apply liquidated damages?
COVID, there's a recent decision from Singapore which has confirmed that COVID is a force majeure event. And under both FIDIC contracts, when there is a pandemic, you are supposed to present a notice. It has to go through the notice procedures. So through that, you can apply for extension of time. So if there is COVID, apply for extension of time. And once there's an extension, you'll be excused from liquidated damages for that period. However, if you do not send your notice, even if there is COVID, an employer would still be entitled to collect liquidated damages from the contractor.
Can the contractor apportion the liquidated damages to its subcontractors in addition to the provision of liquidated damages in the subcontract?
There's a principle of law called privity of contract. In essence, the liquidated damages clause between the employer and the contractor is only limited to only those two parties. If there are subcontractors involved, then there ought to be liquidated damages clauses between the contractor and the subcontractors. So where there's been a delay on the part of the contractor, it's difficult to apportion the liquidated damages amongst the subcontractors unless you show that each of those subcontractors has been responsible for that delay under their respective contracts. So outwardly, it depends, but you cannot pass over your liquidated damages to the subcontractors unless you can show that each of those subcontractors has been responsible for a particular delay.
Okay, thank you. As there is no time bar from the completion date that the contract to submit an extension of time, in case the contractor submits before a short time, such as 1 month, an extension of time is not assessed by the engineer. Then will the contract go time at large?
As there's no time, I don't understand this question. Why do you mean there's no time? Because there's a time frame under the FIDIC contracts within which you should submit a claim. And it is 28 days. It includes a claim for extension of time. So I don't understand when you say there's no time bar from completion date to submit an extension of time. You can submit an extension of time within 28 days from when an event occurred or from when you got to know that event. So you can submit it within that time to the engineer, and if they consider it and it is granted, well and good. If it is not granted, then you go through the claim procedure. You take it to the DAB or to arbitration. But time will not go at large automatically. No, you need to go through the claims procedure.
Okay, thank you. All right, next question says, excellent thus far. The bottom line, however, is to complete the project successfully, notwithstanding the straitjacket mechanism provided in the FIDIC clauses to tighten the contractor. Don't you think it is a better policy or approach to avoid using a nuclear option, i.e. applying delay damages too strictly in the best interest of the project and use it as a deterrence as far as possible?
Well, on one hand, once the delay damages are fair and they have been pre-agreed, I don't see any injustice because both parties need to have certainty when the project will be completed. And in the event that it's not completed, both parties need to have certainty how much liability the contractor will incur. I don't see anything wrong with the delay damages clause if it has been agreed from the onset.
In determining an extension of time claim, can an engineer proceed and de-scope work in cases of concurrent delay, thus granting no EOT, and proceed to slap delay damages on the contractor?
No. Whenever there is concurrent delay, there are various decisions of courts. But the commonest decision of the court is that the engineer is supposed to extend time in respect of the employer-caused delay. And in cases where the delay has been caused by the contractor, then obviously you will not get extension of time because you cannot benefit from your own wrong. So it is not correct for the employer to just simply slap delay damages on the contract. They need to be presented, first of all, because the contractor has the burden to prove the extension of claim extension of time claim, they need to present a proper claim with a detailed delay analysis, which shows the extent of the employer-caused delay, and they'll be entitled to that extension.
Okay, thank you. All right, the next question. In most construction contracts, arbitral awards are final and binding on the parties. In your experience, how easy is it for a party aggrieved with an arbitral ruling to successfully surmount this barrier and refer their dispute to litigation?
The answer is no. Arbitration is final, and you cannot take it to litigation. You only go to court to try and set it aside under limited grounds. For example, if there is fraud, or if there is bribery on the part of the arbitrator, or if the arbitrator has made a decision contrary to what was referred to them, or if the decision is contrary to the law. But I've referred to a Ugandan decision where an arbitral award was partially set aside, where the arbitrator granted both liquidated damages and general damages. The judge enforced the arbitral award, but they only set aside the part of general damages because it was contrary to the law. But it is very, very difficult to set aside an arbitral award. In fact, it's much easier to climb Mount Everest than to set aside an arbitral award.
Can the contract work after the application of maximum liquidated damages?
Yes. If you read the FIDIC contract, it says that the application of liquidated damages will not excuse the contractor from performing their obligation. So even if you've hit the maximum, there still remains an obligation for the contractor to complete the works, though the employer will not claim anything over and above the cap.
Okay, thank you. The next question, what is the difference between liquidated damages and ascertained liquidated damages?
It's one and the same, because liquidated damages are ascertained from the onset. So ascertained liquidated damage is the same as liquidated damage.
What happens if general damages appear to be more than the capped delay damages?
I have presented about a case in Uganda where the court said that where there's delay damages, you cannot grant general damages. So in essence, if general damages appears to be more than the capped delay damages, a court or an arbitrator would set aside those general damages.
Okay, thank you. The next question, in the EOT, is the contractor entitled to claims, or when is he entitled to claim, and how do we calculate it for it?
It depends on the clause under which the contractor claims. There are various clauses under which the contractor claims for extension of time. I think when you meant by claims, you meant money claims, because extension of time is also a claim, but I think your question may have referred to money claims. It depends on the contract. For example, if you are making a claim under force majeure, subclause 19 of the FIDIC 1990, other than extension of time, you're not entitled to any money claim because the employer was not responsible for the pandemic or for the force majeure event. So it depends on which clause you are making your claim. So for as long as you put in your notice on time and you clearly state the event under which it's arising and you are entitled to it under the contract, you can get both extension of time.
The next question, can liquidated damages be set for a design consultancy?
Absolutely. They can be set even for delivery of goods, for as long as you show that by the designer failing to do their work, you will actually lose money as a consequence. Yes, you can set liquidated damages for a design consultant.
It was mentioned that it is a penalty if the liquidated damage amount is excessively high. But what if the liquidated damages stated is not high? For example, like $2,000 per day, but the employer does not suffer any loss. In this case, can the liquidated damages be considered as a penalty?
Well, it depends on the kind of contract. If you say $2,000 per day is not high, but it depends. It may be small works under the FIDIC Green Book, where $2,000 per day may be high. So, but the rationale is that the fact that you've not delivered the project on time and the parties have agreed to an amount, It's very rare that the court or an arbitrator will declare it as a penalty. The declaration of a penalty is in really extreme circumstances, but it's not always the case. Most courts and arbitrators enforce delay damages clauses.
Suppose there is no legal injury at all to the employer in the extension period. Is the employer still entitled to claim liquidated damages?
Absolutely. Ordinarily, when an employer is putting up a project, they intend to use it for one reason or another, or it's part of their strategy. So they don't need to actually present a detailed spreadsheet of their losses because it's pre-agreed from day one. So yes, they'll be entitled under the contract because you agreed from the onset.
The next question, if in the contract it is noted time is essence, then can an extension of time be granted?
Yes, because extension of time is usually granted when there is an employer-caused delay, or even when there is a force majeure event like a pandemic. So even if time is of the essence, what if the employer issues a variation? Then they must issue extension of time.
Okay, next question. Hello, thank you for your nice presentation. The question is related to the FIDIC 1999 book. In the case that time for completion is expired and the employer did not issue the notice for delay damages, neither the claim itself, even after several months, having that the employer should deliver his notice as soon as practicable, is the employer still entitled to apply the delay damages following the procedure explained in clause 2.5 for the whole period of the delay? Can the employer apply the delay damages without previously applied defined claim procedure?
Yes, I've already discussed a case, an English case, where the court said that a delay damages clause is pre-agreed between the parties and that the contractor is well aware of it from the onset. They'll be liable to pay delay damages at a certain rate stated in the contract data. And sometimes it's capped up to maybe 10% of the contract. So yes, you would, but it's very risky because the notice requirement under the FIDIC contract is a condition precedent to any claim. So it is safer to issue those notices. It's in very exceptional circumstances that the court will allow an employer to apply delay damages even without having issued a notice. So issue the notice, it is safer.
Indeed. All right. The next question says, I understand we are dealing with construction claims, but I'm just curious to know if it applies outside of construction and applies to services.
Absolutely. There is an English Supreme Court decision which came out recently. It was about providing software where there was a liquidated damages clause. So yes, it applies to other contracts, not just construction.
From your answer, can we say that the amount of the performance security is part of the total LAD if the performance security amount is less than the total LAD?
Yes. Case law has shown that an employer is not entitled to anything over and above what was agreed in the liquidated damages clause. So, and the purpose of the performance security basically is to safeguard the employer in the event of breach. So if the performance security is over and above the liquidated damages, the employer would only be entitled to that extent that was agreed in the liquidated damages clause. So the over and above amount should be refunded to the contractor.
The next question. So if the engineer fails to provide a determination for a claim submitted, say 5 months ago, the contractor can rely on time at large. Can the contractor use the case law presented during this webinar?
It is safer to rely on a contractual clause because you can never know who would be your arbitrator. Your arbitrator could be an engineer, it could be a quantity surveyor, and most arbitrators put emphasis on what the parties bargained. If the parties bargained on the terms which are in the contract, then you have to follow the contract. If, for example, the engineer has not given you a determination for for a period of 5 months. You can write to them, or you can commence adjudication. You can refer it to the DAB, the Dispute Adjudication Board. You cannot just sit back and then claim that time is at large, because the parties agreed, most especially under the FIDIC contract, that there will be 3 modes of dispute resolution. There will be the engineer to make the determination. The determination is not made, then you go to the Dispute Adjudication Board if it's 99, or the Dispute Avoidance and Adjudication Board if it is 2017, and then you go to arbitration. And then in the 2017, there are deeming provisions. So if the claim is not responded to, you would actually deem it that it has been refused, and then you take the matter to adjudication. So you cannot just sit back and claim that time is at large. You need to follow the claim process in the contract.
After paying delay damages, what is the contractor's obligation for completion of the work?
I think I may have answered it, but the point is that the clause on delay damages is very clear that, notwithstanding the employer's right to claim liquidated damages, the contractor retains the obligation to complete the works. So yes, mere payment of delay damages does not excuse a contractor from finishing their work. They must complete it.
If the contractor fails to complete the milestone completion, can the employer deduct it from the IPA, or need to wait until the final amount?
The employer can actually deduct it, but as you know, the 2017 FIDIC book requires that the employer needs to go through the claim process under subclause 20.2, and it is when the engineer has actually made a determination as to the delay damages that they're entitled to, that then it can be deducted from the interim payment certificate without necessarily waiting for the final account.
If there is a fire caused by a third party or subcontractor, are liquidated damages applied?
It really depends. Now, third party, does it mean that it was unforeseen by both the parties? Maybe if there is a riot, if you read the FIDIC subclause 19 under 1999, it can be a force majeure event. Therefore, you can make an application. You can send a notice in accordance with subclause 20.1 and apply for extension of time on the basis that there has been a force majeure event, and you would be entitled to extension of time. Therefore, liquidated damages will not apply. But if it is a subcontractor to whom the contractor is responsible, then you wouldn't get an extension of time because it's not a force majeure event. And a contractor must have control over their subcontractors. That's the answer I can give you.
Next question. Does it mean that the engineer can disregard a request for an extension of time if it is submitted after 28 days of the event?
Absolutely. Now, it depends on which book you're looking at. If you're looking at 1999, it's very clear that if you don't issue a notice within 28 days, the employer is excused from any liability. Therefore, the engineer has all the right to disregard your claim, however well written it is. So you must ensure that you put in your notices on time. In the 2017, it's more prescriptive that if your notice is late, then the engineer has an obligation to issue a notice to inform you that actually it's late. And then from that time on, you can, if you challenge it, then you take it through the claim procedure. So the answer is yes, the engineer can disregard the request if it's submitted out of time.
Again, get your notices in on time.
Absolutely.
All right, next question. Are the damages apportioned amongst JV partners in case of a JV? Are there internal conflicts considered, especially where the other party feels that their JV partner is the cause? Sorry, I don't know what a JV partner is.
It's a joint venture partner.
Oh, okay, thank you. Sorry about that.
Yeah. The answer is, you know, there are two things here. When you do a joint venture, you're deemed to be one party, and the employer is deemed to be the other party. So if there is liquidated damages, the employer is at liberty to claim all of them from any one of the joint venture partners, because the liability of joint venture partners is joint and several. It means that if there's a liability of X amount, the employer is at liberty to claim it from any one of you. And then amongst the joint venture partners, if you're dissatisfied with how the money was collected, you can commence a separate action to claim contribution from the rest of the joint venture partners.
Is there any limit of percentage for liquidated damages amount against the contract value?
Yes, usually in the contract data or appendix to tender, there is a limit. You can put it at 5% or 10%. But under the FIDIC 2017, in the event that there is any fraud or willful misconduct, an employer can actually claim over and above the capped liquidated damages.
Okay, thank you. All right, next question. Can a contractor claim escalation of price even when it is not provisioned in the contract for reasons not attributable to them?
It depends on the type of FIDIC contract you've chosen. As you know, if it's the silver, it is a fixed sum, turnkey. The risk is entirely upon the contractor. So even in case of escalation, you cannot make a claim. For the yellow book, it is fixed sum. That's the risk that you've agreed to take. So even if there's escalation of price, you cannot make a claim. There are limited claims you can make under the FIDIC yellow book. If it's the red book, basically the payment is based on measurements. So in case of price escalation, you can make a claim. So it depends on which type of FIDIC book you've actually chosen.
In FIDIC 1987, is a notice a condition precedent for the employer to apply liquidated damages? If he deducts from the interim payment certificate arbitrarily, is it in order? Wow, really going back to FIDIC 87. Do you remember that one?
Well, no, I don't remember that one. I don't remember that one. But the best I know is that the condition precedent has just been introduced in 2017. Previously, there was never a condition precedent of time limit for the employer to make a claim. Liquidated damages were agreed from the onset, so they would actually deduct it for as long as they have computed it in accordance with the appendix to the tender.
Is contra preferentum as a legal doctrine when it goes to arbitration in delayed damage cases?
Absolutely. The contra preferentum rule is a legal principle that states that in case of ambiguity in clauses in the contract, the contract will be interpreted against the maker of the contract. That's what it means. Usually the employers prepare the contracts. So the answer is yes. The contra preferentum rule applies in arbitration for as long as you show that contractual clauses are ambiguous.
Next question. The performance security is a separate contract with a third party, the employer or guarantor. If correct, should the performance security be treated separately from delay damages provisions or treated with and including liquidated damages?
Yes, it's a separate contract, but it has an obligation in a sense that the issuer or guarantor tells the employer that I will pay you if the contractor breaches. So in essence, where the contractor breaches and the employer is entitled to delay damages, obviously the guarantor is supposed to pay that money. So they are interconnected. You can't separate them.
In some countries, unlimited, liquidated, and ascertained damages is illegal. It is limited to 5%. Is that reasonable?
It depends, really, because what is reasonable to you may not be reasonable to one another. And some countries, most especially Commonwealth countries, they emphasize freedom of contract. If the parties have sat down and agreed that their liquidated damages will be up to 10%, the courts, most especially in the Commonwealth countries, will enforce that clause based on freedom of contract. The courts don't want to rewrite clauses for the parties. But in some civil law jurisdictions, or even in the UAE, if you actually show that a clause is unfair or is unconscionable, or if you show that the employer is set to be unjustly enriched or to unjustly benefit from the clause, the court or arbitrator may actually set it aside. So it depends. There's no straitjacket.
Okay, thank you for answering that question. And that was the last question. Thank you very much, David.
Thank you, Jennifer. Have a good day.
Thank you, you too. Bye, everyone.